Hi, welcome to the business law business contractual relationship lesson. The focus today is to discuss about the law of sales of good. So previously we discussed about the contract law, the law of contracts, as well as the agreements and things like that. And today we are going to discuss about the merchant laws. Basically, the laws which are regulating the environments of selling of goods. So, since this is very sort of this presentation is basically emphasizing on the laws of which are related to the sale of good, or let's say that is the transfer of the title of the goods. So we'll go with the presentation itself. Okay. So today's lesson outcomes are define the contract of sales of good and understand the characteristics of a contract should contain and the nature of the contract of sales of good and distinguish the sale and the agreement to sell in some sort of circumstances. There are so many circumstances where we are going to discuss today. So with that, how the sale or let's say the real-time sale and the agreement to sell differs with these circumstances. So that is those are the areas that we are going to discuss today, and also understand the nature in the circumstance of insolvency. Now, when it comes to an individual person, we call it as a bankruptcy, but when it comes to a sort of a business entity, we call it as a commercial entity. So we call it as an insolvency where you don't have the necessary assets to pay over your liabilities. In that circumstance, how that be affected, how those incidents will be affected on the circumstances of sale or the the agreements to sell of goods. And also we are going to identify the types of the goods in contracts. Okay, so here we go. So what do you mean by a contract of sale of goods? Now, previously we've discussed about the contracts in the general circumstances. Like, let's say, contracts were, as we discussed, the contracts are some sort of agreements between two or more parties to conduct sort of an or to perform some activity or to make something. And there are some considerations known as financial, value in some sort of a financial value is there. So these much of things we were discussed. Now here, contract of sale of goods. It says that it's about the sale of goods. The contract is all about sale of goods, right? It's clear. Now, what do you mean by a contract of sale of goods? As in the presentation, we can easily define it as a contract whereby the seller transfers or, remember, transfers or agrees to transfer the property in the goods to the buyer at a price. So simply it says there are two types, right? One is seller transfers, which means that he's selling it, right? In the day-to-day life, whatever the things that you need, you will go to a shop and you will buy them. So that is called sale, right? But when it comes to the legal or let's say the business or commercial agreements, of course, there are some sort of agreements happening where at the same time, let's say, if you even though if you want to buy some product or a service from a seller or let's say a merchant, but you won't receive that particular good at the time, or let's say you won't pay a sum to buy that particular thing at the same time. So you're not going to buy it at the same time, right? In other words, but you may have some agreement with the merchant to buy it, or let's say the merchant will give you an offer to sell it. So in that circumstance, you may have some sort of agreements. So that is what we call as the agreements of sale of goods. So in that case, seller does not transfer the title, or let's say this is here the property is known as the title, or let's say it has the ownership of something, right? Don't mislead with this, the concept called property. Property refers to the title or the ownership of that particular good or service. So by, let's say, if I'm having a good, you are the consumer, so I will send it to you or I will transfer it to you at a cost known as the price. So if I sell it to you in the sense, once after I sold it to you, so the title or the ownership or the property is with you. You are the owner, right? So that is the case. Now here in the sales seller transfers or agrees to transfer. In a future time, you will, this is not all about, receiving some sort of a commodity once after you made the payment, right? Now, in an event of where you are, let's say in any circumstance of whenever you are purchasing a commodity, let's say a furniture from a furniture showroom, they might be not having sufficient stocks with them, right? So once after they got your payment, once after they received your payment, they will agree to perform it, which means that they will deliver the commodities. That is not the case here, right? Let's say the pay terms. As an example, agreement to sell, right? So once after the reservation of a product, let's say, simply, you are reserving a product for your future consumption. Let's say at the present you don't have money. Because of that, you will ask the seller to reserve it for you. So you will buy it. Let's say during this season, you will ask the seller to reserve some sort of a commodity or some sort of a product for you, and you will buy after this corona, this thing is over. So that is what you call as agreement. So if the seller has agreed, let's say you may have probably signed a document, implying, let's say, expressing this agreement. So in that case, it's particularly clear that you and the seller are having an agreement where seller agrees to sell it to you. You agrees to buy. You agreed to buy it, right? Now, when it comes to the characteristics of the contract of sale of goods, we can see these types of things. There are two parties known as buyer and seller. It's clear. And transfer of the property. As I told you earlier, the title or the property or the ownership of that particular product will be transferred to you, right? And also there should be a good, right? Otherwise you can't, claim the title, or let's say claim the ownership. Contains both sale and agreement to sell, right? Which is a future circumstance. No formalities to be observed, and there's no proper format of, the proper form of making these types of contracts, where if the seller and the buyer are, mutually agrees to perform some sort of agreement terms and conditions. So you can mutually conduct your, mutually perform your contract of sale of good, right? So that is the case. So you know now what are the characteristics should be there in the contract of sales of goods. Fine. Then I told you, there are so many circumstances where you are encountering with on this sale or the agreement to sell, right? Because this is all about, transferring the title of, or the transferring the property or the ownership of a good, right? It can be you may be paid for it, or you maybe have an agreement to pay for it, right? In a future circumstance, let's say for a convenience good, for day-to-day need, you are not going to make some sort of, of course, with the credit cards and these things and that thing, you might pay the sums in the future, but of course you are having an agreement with that particular the seller. Now, the role of a credit card, what is that? You may have agreed with a bank, right, to make a sort of a credit facility. The bank has been entertaining you with a credit facility, and you are using it, right? There's no much difference between this agreement to sell and this thing. But when it comes to the credit cards, of course, you may have agreed with some of the terms and conditions with the bank. You will buy because you don't have money. Because of that, you will use the credit card, and on the credit terms and conditions, by agreeing to them, you will make your payment, purchase, right? And at the same time, you will make the payment to the seller. But seller doesn't have any sort of a legal, he will always, like, he's already been received the sum which is due for him, but at the same time you will make a liability, or you will make a sort of a legal relationship with the bank to pay that sum, right? That is one way of creating agreements, right? These are much complicated, so that is why I'm telling you always to go with these slides. Okay, so we'll see how they're transferring the property, transferring the title, transferring the ownership, right? In a circumstance of transferring the property, See, as it's mentioned in the slide, sell. Sell in the sense that you will, at the real time, the seller ceases the ownership of that particular product and the buyer will receive the ownership of it, right? Transfer of the property. Sell, immediate cease of the title from the seller and ownership becomes the buyer's. It's buyer's baby now. Once you have made the payments or else you have agreed to make the payments, the transfer of the property, in a sense, the title will come under you. If you are the buyer, it will come under you. And it will automatically, at the real time, that will cease the ownership from the seller. Though the commodity is still kept by the seller. Because you have already made a sale, right? Then when it comes to agreement to sell, agreement, right? There's an agreement to sell. Ownership of the goods transferred to the buyer at the time of the contract. Once you have signed, right, or once you have expressly, agreed to sell, you don't want to pay, right? Once you have agreed, that title will go to the buyer. Let's say you have agreed with the seller to buy some sort of a commodity and you may have signed an agreement. So under that sense, the commodity, the title or the, you can claim for that particular commodity, right? The title or the ownership is coming under you, right? Even though the seller is having the commodity, right? This is the nature. So see, seize the ownership of the seller at the same time. Okay, once you have agreed, it will seize the ownership of that particular goods from the seller. Right. So we'll move. Then the circumstance 2 is risk of losses. Risk of losses. Be careful, because once you made the payment, the ownership comes under you, right? If you are the buyer, if you made the payment to the seller, if it is a sale, real time the title will be transferred to you because you have already made the payment and you have the ownership of it. Ownership on them, of course, right? So be careful. Now, in an event where the sellers are transferring, or let's say sellers are delivering a particular commodity to you, once after you made the payment, it's your baby, be careful. You cannot claim over the damages whatever happening to that particular commodity. So be careful, right? Because you have already made the payment and the ownership is with you, right? It's up to you to recover your whatever the losses, right? See the example, sale, right? See, real-time seizing of the title or the property, or let's say the ownership of a product. The loss comes to the buyer even though the product is not delivered him yet. As an example, if seller was, let's say he met with a fire and your commodities have been damaged, so because of that you cannot claim over them, because you know why? You have already made the payments and the title of the ownership has come under you, right? Then the second circumstance, agreement to sell. You have an agreement to sell, right? If the title is about to transfer, read it carefully. If the title is about to transfer to the buyer, the loss has to be borne by the seller because it's not transferred yet, right? The title hasn't transferred yet. But of course, if you have signed an agreement saying that, okay, the title has been transferred, in the sense the title is transferred, right? Make that point. If the title is transferred, there's no guarantee to say that the seller is having the, seller will seize the ownership of them and the ownership will come under you. Okay, right? Now read carefully. If the title is transferred, then the buyer has to bear it. If the title is transferred. But if the title is not transferred, though you have agreed, but still you haven't signed any sort of a contract, or you haven't signed an agreement on these commodities, then the seller has to bear it. Or let's say the seller has to perform that particular promise because he has agreed, but of course he can also neglect because you haven't come for an agreement. No? And under that sense, of course, he can withdraw the promise as well, right? Because there's no legality on it. because you haven't signed an agreement yet. Okay, right, that is the second circumstance. Then the third one, consequence of breach. Be careful. We were discussing about the breach of contracts, but not in a very informative, or let's say in a descriptive way. We've discussed about the breach of contracts. There are some other in a circumstance where one party may not be able to perform a term or a condition of the particular contract, in the sense that will breach the contract, right? That will breach the contract. Fine. So when it comes to a sale of a consequence of breach, right? If the buyer breaches, the seller can sue the buyer for the price. If the buyer breaches. Now let's say, once after he sold it to you, right? You may have breached a condition of the particular agreement. Or let's say, you may have breached some sort of, let's say, if the buyer breaches the seller, if the buyer breaches, the seller can sue the buyer for the price. That is called consideration, right? Okay. Even though the goods are still in the seller's possession. That is called, let's say, as an example, you made a payment, right? So you became the owner of that particular goods, right? You made the first payment, let's say installments, right? You made the first payment, which means executed already. So in your second payment, you will not make it. But still the commodity has to be come to the seller even, right? They have ordered it from a foreign country maybe. It has to reach to the seller even. Now, still the commodity is not with you. Because of that, you will breach the contract, saying that the what do you call, the delivery time is very, it's getting delayed. Because of that, I'm not going to make payment. But make sure that seller imports all these products on behalf of you, right? Because you made an agreement of sale, right? That is called sale. So the title of the ownership has come under you. So you cannot say, you cannot breach the contract. If so, if you have breached the contract, if you have breached the term, so the seller can sue over you, right? The seller can sue you because you may have breached the contract rules. Second one is agreement to sell. Now, if you are having an agreement to sell, read carefully. Seller can only sue for the damages even the goods possession with the buyer, right? If it is an agreement to sell, seller can only sue for the damages, right? Whatever the damages only, even the goods possession with the buyer, right? Even though the goods are with the buyer, the seller can only sue for the damages whatever he experiencing, right? Okay, so these are the consequences of breach of a contract. Fine, or a breach, right? Then the fourth one, right of resale. Now, assume a situation where most of the times these are happening to the land sellers, right? Not the corporate type of land sellers, but when it comes to some of the brokers, some of the land sellers in small and medium term land sellers, right? They do this, right? And there are so many cases at the courts because they may have resell that particular land to another buyer, right? Without knowing that the land is already being sold to another, so they will also pay and they will also buy, right? By that can be happening through creating the fraudulent deeds and all, right? Anyway, those are like financially fraudulent conducts, and also that is called those are can be considered as not the wrongful conducts, those are crimes, right? Because those are not civil wrongs, right? When it comes to intentionally or unintentionally making the others, in the sense we discussed those things in the laws of torts as well, right? Not just because of the negligence, but of course those can be considered as crimes, right? You will mislead the people, right? Okay, so right of resale. Now, suppose if you are a seller, can you resell a particular product which is already been sold to a buyer? No, you don't have the right, because once after you sold it, it's sold. So which means you have transferred the ownership from you to the buyer. You cannot resell it, right? Now, when it comes to a sale, since the title is transferred under the just in rem, just in time, let's say, just in rem principle, the seller cannot resell the product to a third party, of course, right? Even if a product, the third party will buy a product, he must be, even he can be insane, or else the person doesn't have the sufficient knowledge about the previous sale, right? Okay. Then the second one, agreement to sell. Read carefully. If the goods are remain with the seller can sell it to another party who doesn't have a knowledge, right? Agreement to sell, right? You have agreed with another party, okay, I will give this to you, but still, if the offer is high from the other part, this is what often happening in the land sales. If the other, what do you call the rate, or let's say if the price of the other party is very high, so you will try to sell it, right, to another party at a high price, right? But that person doesn't know about the previous sale. You may have made a commission, or you may have made a sort of an advance for that as well, the previous one, right? So who doesn't have a knowledge over the previous sale, where the buyer can sue the seller for the breach? Yes, of course, because suppose there are three parties, myself, you being the buyer, and your friend is another buyer, right? In that example, I will first agree to you to give you the land at a price of, let's say, X amount, right? That is the price. So at the same time, once after I agreed to you, you won't buy it, right? You won't buy it for, at the same time, you won't buy it. But we have an agreement to sell, right? So I have agreed to you to sell. Then you being the potential buyer, you are waiting for it, right? But neglecting that part, I will receive another offer from your friend asking that particular land, because he doesn't know that you have already bought this and I have already agreed, right? So without that information, without that knowledge, he will come to me and ask for me for a land which he will offer me a higher price, let's say. So in that circumstance, even though I received a sort of an advance payment from you as the promissory leader, that is a consideration, right? So even though I have agreed and I have received, a sum from you, but just because of the high price, right, I will sell it to him, right? I will receive a sum from him and I will sell it to him, or I will agree to sell. In that case, if you, anyway, that is uncomfortable situation for you, so because of that, you can sue me, right? So that is the case of right of resale, right? Which are much, those were sort of much complicated. If you do have any concerns, of course, you can send me the mails and you can clarify them. And we'll move to the insolvent situations, right? So insolvency can be happen to the seller or the buyer. Insolvency means that the company or the buyer or the seller doesn't have sufficient assets to pay over their liabilities, right? The debt is greater than whatever the assets that you have. So you don't have sufficient assets to pay over your liabilities. So in that circumstance, normally, remember again, a person can be bankrupted, but the company is to be the insolvent, right? A person won't be insolvent because it's not an entity, right? Right. So the corporate entities, let's say insolvency of a buyer before he pays for the goods. Before he pays, right? This is the insolvency of a buyer. So when it comes to circumstance of sale, now there are two things. No, one is circumstance of real-time sale. The other one is the agreement to sell. In the case of sale, in an insolvent situation, seller should deliver the goods to the receiver or the assignee, right? If your entity being considered as insolvent, so the regulatory parties will appoint an administrator or the official assignee to resolve all these conflicts. Let's say to pay over the liabilities and resell the assets and things like that, right? Sell the assets and to pay over the liabilities. For that case, and also to negotiate with the parties who involved in the business contracts and things like that. So in that case, the seller cannot neglect that part, because since they have agreed, right? Probably, buyer, before he pays for the goods, right? Before he pays for the buyer hasn't paid yet, but still, since it's a sale, you should, the supplier or the seller should send those commodities to the buyer's assignee or the official receiver, right? That is how you can resolve this conflict. Then when it comes to circumstance of agreement to sell, now you have an agreement to sell before the buyer pays for it. In an agreement to sell, the seller may refuse to deliver the goods to the official assignee unless paid for, as ownership has not passed to the buyer. Now, in that case, the seller is having the sole right to refrain from delivering that particular product or the commodity to the particular buyer, because he hasn't paid yet. You're only having an agreement, and obvious that he doesn't, or let's say the company doesn't have enough assets to pay over. So because of that, you can refrain from doing it, or else if the person has already been paid for it, or the company has already been paid for it, you must send them to the receiver. So this is the case in an insolvent situation where the buyer has not made the payment. Now let's see the insolvency of a seller if the buyer has already paid the price. Now we are assuming that the buyer has already paid the price, but the seller is insolvent, right? Be careful, okay? Right, so the circumstance of sale. At the circumstance of sale, the buyer is entitled to recover the goods from the official assignee. Once after you declared as an insolvent entity, the official, the receiver or official assignee will be appointed, and the buyer can, recover the cost of those goods, or let's say recover even the goods, right, from that particular assignee, right? It's a different matter if you do not have the commodities. Of course, you can claim for the amount that you have paid for, right? You being the buyer, if you want to receive some sort of, the amount that you have spent already, so you can ask for an amount that you have spent, right? Because you didn't receive any sort of a commodity yet, okay? But when it comes to the circumstance of agreement to sell, buyer can claim only for a rateable dividend. Rateable dividend, right? If the paid amount can be settled as a creditor, right? If paid, the amount can be settled as a creditor. You can add it to your balance sheet and you can brought it forward. I mean, you can brought forward the amount. You can make it as a brought forward balance to your balance sheet. Because why? When it comes to your it's a sort of a receivable, right? Because at the same time you won't receive some sort of a money, right? Because they don't have sufficient funds to pay over you. So because of that, you will be considered as one of their creditors, right? So you can consider them as one of your debtors. In that case, you will receive a rateable dividend from your particular seller. Okay, right. So we'll move. So this is the final slide, like whatever the areas that we are going to touch today. The kinds of goods in contracts, right? We can sign the contracts for these types of goods. There are basically three types of goods, and the first one is the existing good. Now, whatever the goods which are in the existence are known as the existing good. The goods which are physically in the existence and which are in seller's ownership and possession at the time of entering into the contract of sale, right? Existing goods, right? Those should be available in a physical mode, right? Then there are sort of two sub-varieties of those known as specific goods as well as unascertained goods. The first one is a specific good where the goods identified and agreed upon at a time of making the contract of sale, right? Goods identified, separately identified, right? These are the goods that I'm going to, you name it, right? These are the goods that I'm going to buy. These are the goods that I'm going to purchase. It can be a one refrigerator, one television, and so on and so forth, right? You will select them physically, and those are very specific. But when it comes to unascertained goods, right, though they are the existence, right, you are not going to, separately identify them, right? So goods not separately identified and agreed upon at the time of making the contract of sale. You may have seen some of the now, especially whenever you are for company purposes, right? If you are reserving a vehicle to be purchased, that particular vehicle number, I mean the chassis number, all these, whatever the specified numbers which are relevant for the separately, separate identification of the particular product will be taken into the consideration and will be included in your agreement, right? That is to specifically say that this particular product has already been allocated to your company, right? But if not, let's say though they are in the existence, there are so many lorries available and you are a delivery service and you may need to buy a delivery vehicle where the vehicles are available, but still that person hasn't given you a specific or separate, this lorry will be your lorry in future, right? That person hasn't named a particular commodity. So those are coming under the unascertained goods. Though they are available, but those are unascertained, right? Right, this is a simple idea. Then moving to the other part, we can see there are another two types of, the other one is future goods. Future goods in the sense, goods to be manufactured, produced or acquired by the seller. Now, even though you have came into an agreement, but still, still they are having the authority to sell them, right? The sellers are having the authority to sell them, or let's say that can either be a sale or a agreement to sell. Now, when it comes to future goods, of course, haven't made it yet, but still they can be in the processing plant. The seller can agree the buyer to sell a good which is not yet manufactured, right? Within 2 weeks, I will bring your whatever the let's say now whenever you're purchasing some of the furnitures as well, you may have experience, right? Especially the furniture shops in some furniture shops, you may have seen that, because since we don't have the stocks, we cannot tell you what exactly comes, because you cannot let's say there is one way of unsold, right? That is not specifically it's not unsold, but of course you cannot specifically show it to the customer, right, or the consumer. So in that case, it comes under the future goods which is not yet manufactured, right? Fine. So then the contingent goods, the acquisition of which by the seller depends upon the uncertain contingency. In circumstances like this, contingent goods, right? We even don't know, we being the sellers, we even don't know when we will be receiving the commodities as such, right? If we have received it, definitely we will giving it to you, like we will be providing it to you. Under that circumstance, you may also can have the agreements and you may also can receive the payments based on the sale, right? Goods, the acquisition of which by the seller depends upon the uncertain contingency, right? Okay, so these are the things what we have to discuss today, what we had to discuss actually. So if you do have any concerns, please let me know so I can help you out through. And if you have any sort of clarifications to be done, you can mail them to me and get things clarified. So thank you very much for joining with me today. Hope you guys enjoyed the session. Thank you.